Good morning for me, at least, from Montana as well for me. So I'm on the road again. So the second half of our week, our first week on death and dying, we're really focusing this week again on the right to die, which includes we reviewed what passive and active euthanasia were, what kinds of things have been defined as legally allowable, which again is mostly passive euthanasia, although in a few states we do have some active euthanasia laws, which we will talk about next week. And also, we talked about what types of measures might be included in the Right to Die, right? Right to Die initiatives, as well as some of the sticky ethical issues, and family issues, legal cases, in things like very important legal terms such as substituted judgment, right? So a lot of these cases hinge on substituted judgment and best interest, but what would the person have wanted in their stead, and some evidence that we can find that. So this part of the lecture is really on your substituted judgment and putting this down ahead of time on paper, certified by witnesses, potentially in another legal document, certifying a healthcare agent for you, so that some of these wishes are, in fact, will be enacted. You don't end up like some of the people in some of the cases, such as the Terry Schiavo case, or I believe is the Brown case, where your substituted judgment cannot be enacted because they can't find evidence. So that brings us to advance directives. So as budding gerontology people, you're going to probably face this, if not in your personal life. Well, you certainly should face this in your personal lives, but also your professional lives, particularly if you're in a healthcare setting, acute or long-term. You will likely be faced with someone who has advance directives, wondering whether to follow them or not, what the legality of these certain documents is, and liaising with both family, which are generally next of kin found to be proxies, like the next proxy, they will go to a partner or spouse or adult child, sibling who's either been, deemed the executor, or everyone has appointed as, this is the person who represents us. A lot of times they will look to those people as proxies unless you have someone legally designated or someone different legally designated. So this is when we're making decisions about healthcare and what to do. And certainly these can apply as well to things like finances, although there are other legal things like will and testament and things like that that apply to finances and legal estate. Advanced directives are mostly about what is a good death, spelling that out, putting that down in writing, getting it witnessed, and the right to be able to have substituted judgment. Under the bigger umbrella of what is an advance directive, you might hear this word and be like, well, what? How is that different from a living will? How is that different from a healthcare power of attorney or a power of attorney for something else? Essentially, they're kind of under the same guise. They're just different types of them. So as the picture here points, you might have an advance directive that is more of a living will document, which we'll show a couple of examples of some of those. But those are essentially spelling out what you would want for life-saving measures or not when it comes time for you to be terminal and you don't have the ability to make your decisions anymore. And a healthcare power of attorney is a different type of legal designation where you draw up documents, you would identify a healthcare agent and share with them your wishes. Your wishes might be part of the document. You might have also a living will, but that person, that healthcare power of attorney, is designated as your agent. If and when you cannot make your own healthcare decisions, they are legally able to represent you and make decisions for you. A lot of times those people are family, but sometimes you have a long-term relationship with a lawyer, you have a long-term relationship with a neighbor, a very close friend. You may not, if you're outside a nuclear family situation in society, we think about like LGB elders who may or may not have siblings, family, adult children in their lives anymore, and they may designate people who are more in their family of choice, or other types of family or grouping situations where family of choice is more important than biological family. You can designate a healthcare proxy or a healthcare power of attorney who is not a family member, certainly. A do not resuscitate order, which we'll talk about a little later as well, is under this because it is definitely an advance directive, spelling out what you do or don't want. And also donor registry. So we don't think about that a lot, but even just marking that on your driver's license, I would like to donate my organs, is a form of an advance directive. But there are further things you can specify, such as I want to donate my body to science. If I get dementia, please donate my brain, those kinds of things. If I have if I have a disease, please contact the right people, and I would like my body to be used for the better, to better research. I have a lot of people who might have things like Alzheimer's or other types of dementia who that's part of their living will, or that's part of their wishes, right, that they want enacted if they aren't able to say that when it comes time for them to die. I want to mention a couple of things about advance directives here, because it can get a little tricky, right? And, which one is which and which one's legal? Certainly, all of them have some form of legal validity in the United States. You don't need a lawyer, per se, to fill out an advance directive. It's legally valid when you sign it in front of required witnesses. So every state has some fairly specific laws about what an advance directive has to have in order to be legally valid. A lot of them overlap, so they're the same, which is why some of the documents out there you could sign it and do it, and it would be valid across states. But that's another problem that we'll talk about next when I go over some of the limitations of ADs. Is that laws vary from state to state, so making sure that your advance directive, if you relocate, is both seen and heard and valid is an important step. Other interesting thing about this is that emergency medical technicians cannot honor living wills or medical powers of attorney, because once they're called in, they have to do what's necessary to stabilize a person. So there are some limits to some of these things, which we'll talk about here. But I just wanted you to know that all of these things, most of these things have some kind of legal validity to them. It's just there are limits. Okay. So there are a lot of legal restrictions that kind of make advance directives and not a magic bullet for telling people what you want. So I'm not here to say don't fill out an advance directive. That's exactly what I want to steer you away from. Everyone should have some kind of advance directive, whether or not it ever gets enacted or not. That's a different story. But in the case that it would, you would be at the point where you wouldn't be able to have your own wishes be said anyway. So these are things that are important, but we do have some limits on advance directives in general that make these not like this universal document that's fantastic, and of course everything's going to happen the way you want it, right? So one problem is just the low rate of uptake. So not a lot of people fill out advance directives. Not a lot of people know about them, know about their limits, know about their legal validity, understand what really one is, and maybe have some of these informal conversations with family, but maybe not, because as we know, talking about end-of-life issues is extremely taboo, and not a lot of people do it. One of those really sticky adult-child aging parent conversations, right? So we're talking group discussion 3 here. Also, they are found that one of the limitations of advance directives, which you saw in some of the court cases, is if you're very specific, like way too specific, that you rule out some conditions, like if this, if X, Y, Z, A, B, C, D, E happens, then you can do this. But then you just ruled out if X, Y, Z, A, B happens, then do this. So sometimes you can get a little too specific or narrow, and on the opposite side too vague about what you want, and then you leave a court potentially or a facility open to liability here because they don't really know what you meant. Like the court case where the woman who said that if she was terminal, she didn't want a ventilator, didn't want a feeding tube, but she wasn't terminal, it was irreversible, and then they wouldn't enact it. So those are just some examples. Also, not universally applied, which I mentioned about the states, right? So that's one universal application that is currently limited, is that there is some evidence that, laws that vary state to state will affect whether or not your advance directive in, if I'm in Montana, is that going to work in Kansas? Well, what if I move to North Carolina? So those are things to keep in mind. And that's why we recommend things like 5 Wishes, which I'll talk about, which has 46 of 50 states approved, right? And there are a couple of states that you have to fill out an additional little thing, but they are very clear about those in the 5 Wishes document. Knowing whether or not this is going to be considered official. So I will tell you that just because you have an advance directive out there doesn't mean that your healthcare provider has it, that the facility you're in has it, that they know and understand what it is, and that there aren't other types of competing documents or things that could come into play. So one example might be if you're in a facility and you have a healthcare power of attorney, and this healthcare power of attorney may not be a family member, or maybe a family member who isn't particularly close to others, and they are acting in what is your substituted judgment, but other family members, a lot of them are speaking very loudly or not okay with this. Let's think about the Terri Schiavo case in this sense. Facilities are in a hard place. Doctors are in a hard place. We've got the majority of your family clamoring that don't you dare take her off of this. This isn't what you would have wanted. And then you have this healthcare proxy. Sometimes things happen and you don't get your wishes that were written down said because these competing voices are there. And that's a very sticky situation for people to be in. Also, there are some things that in advance directives that may be limited. So we have to know legally what you're able and not able to say yes or no to, right? We talked about the difference between active and passive euthanasia. There was a recent case in Oregon where a woman who said, if I'm demented, I don't want someone else to help feed me. And she became demented, and the facility was trying to follow that, but the state got involved. Pretty soon they said, well, that's not in our ability to do. We have to feed you when you're able. So the difference here is between an active treatment feeding tube, which she did not need. She could swallow and chew and all of those things. She just couldn't physically feed herself. So that having someone help you with eating, where you can swallow, chew, all those things, versus inserting a feeding tube. Inserting a feeding tube is something you can choose or choose not to have. The feeding, when you are able to eat but just not able to feed yourself, that's something that you're not necessarily able to choose unless sort of at home in the privacy of your own family. So those are some nuances of knowing whether or not your advance directive will be considered official. And I mentioned the lack of reciprocity in some states. So just because it's valid in one state doesn't mean it is in another. So I'm not trying to scare you here about advance directives and that all of a sudden, your family members or you are not going to be able to have what you want happen. That's not necessarily the case. But it is important to go into filling out an advance directive and your own healthcare understanding these limits. And that's why we as gerontology or gerontologists in training need to know these limits and understand for our clients and for our family members that there are limits to these documents and how to help support them in the best way that we can if, in fact, we're in those situations where we have to be an advocate or we want to have the older adult have the best information that they can. Okay, so I wanted to bring up 5 Wishes. So if you haven't heard of this before, Aging with Dignity is an organization that is very pro-advance directive. Obviously, they want everyone to have their good death or what they want as a good death. And this is in, again, in the mostly in the passive euthanasia area, right? Because this is a document about what is a good death and not assisted death, which is next week's discussion. So in 5 wishes, I just want to go ahead and I'm going to switch your screen here so that you can actually see a sample 5 wishes document. Okay. So this is a sample 5 wishes document, and what the 5 wishes is it was a simplified document to help people fill out a living will or advance directive. So the areas are the wishes, or the 5 wish areas that you go over when you run through this document as an individual or with a family is you decide who I want to make decisions for me when I can't, the kinds of medical treatments I do or don't want when I die, how comfortable I want to be in the end of life, how I want people to treat me, how I want others around me to healthcare and family, and what I would want my loved ones to know. So this document is considered to be legally valid in 46 out of 50 states. And they go through and they talk to you about what 5 Wishes is. The Aging with Dignity organization has created this and in concert with legal consultation as well as aging professionals and their own expertise to be able to say this is a legitimate document. So these are the states, 42 out of 50 states, and the District of Columbia. And there are also other states that they have listed that have like small additional documentation that you have to fill out that's like a witness form or something that's very specific to the state, but they also tell you about those. So they tell you how to change your 5 wishes if you want, so how to change this advance directive or living will document. And then they go through each of the wishes and they kind of help you make these decisions, particularly when you're trying to understand, what does the healthcare agent do? What would this person be able to do? What do I want for the medical treatment? This is really great because it talks about what is life support, what would happen in the case of emergency, when I'm close to death, when I have brain damage, if I'm in a coma, another condition. So they help you kind of give a lot of options. And think about these things, how comfortable you want to be, how you want other people to treat you, and what you want your loved ones to know. So this isn't necessarily about your own healthcare, but this is a really important one because you want your family to understand. You want to be able to communicate some things to your family as well that aren't necessarily related to what kind of healthcare measures you want. Then you sign it with witnesses, and it has to be notarized when you're in Missouri, North Carolina, South Carolina, or West Virginia, and then it tells you what to do with it. And some other, sort of state examples. So if you're in this state or if you're in this state, you need to do these extra things. Okay. So that is a sample of one of what we would consider probably the gold standard of assistance for advanced directives in the gerontology community. 5 Wishes is very well known among professionals and well utilized. All right, I'm going to go back here. So another interesting thing that I ran across was these physician orders for life-sustaining treatment, which is the POLST organization. So this isn't necessarily a living will per se. It's not something that you would do way ahead of time. This is something that you would do if you're seriously ill or coming up on a situation where you think, well, I'm going to need these physician's orders, these orders to follow when I'm sick. So when you have loved ones or when you're doing end-of-life care planning, physician orders for life-sustaining treatment is sort of another step. So it's translating what you want into actionable physician orders that you can bring with a document. And these are a group of healthcare professionals, physicians, et cetera, and their organizations in most every state, including Kansas, that have help available or assistance, or have a place where you can send in your documents and help have these translated into physician orders, and then you would have those ready for you to talk with your own physician. And I will say this is another limitation potentially of advance directive, is that your physician, your personal physicians, this isn't like if you're in an HMO or a larger healthcare organization or a long-term care setting, they're obligated in a lot of ways to talk to you about advanced care planning, but your personal physician is not. And they have the right, of course, every personal physician or healthcare person has the right to say, I'm uncomfortable with fulfilling these types of things. It's sort of, I don't feel like when it comes time, I'm going to be the right person for this. So they can deny doing those things, that they will do those things, but then they are obligated to provide, assistance with referring you to someone who can fulfill the wishes in your advance directive, as long, again, they're in line with legal, what is legally allowable. And I thought this was interesting too. I don't know if any of you have ever seen this, but these are individuals, and there are lots of these. If you Google, do not resuscitate or living will tattoos, it's really interesting how many that you get and how many pictures and how many people, particularly the do not resuscitate orders, right, which are very, very, very narrow and specific form of an advance directive, which is if I am in cardiac arrest, my heart stops, etc., don't bring me back, right? So people have had these, these types of tattoos, more creative potentially, do not intubate, do not reanimate, and then this one, is a much more complex, even with little signatures here, sort of their living will on their forearm, which I guess sort of it speaks to the point of if your documents aren't readily available, here it is on your arm. But again, just because you have a tattoo doesn't mean that it's necessarily legally binding and that people are going to have to follow it, but it is something that is sort of a reminder when you're in situations where maybe you don't have any documentation with you, which happens a lot in emergencies. It sort of conveys your wishes, and I think is pretty good evidence of substituted judgment if you tattooed it on yourself. Okay. So we've gone over a lot of things, like I said, in the right to die. And the bottom line here is that these are very sticky issues. This is something that we deal with in particular as gerontologists that usually doesn't come up as much. It does somewhat in adult or young adult populations where we have like terminal illnesses such as cancer. But really, it's kind of a specialty of the aging person. So these are really important issues to think about, discuss, and talk about and think about how that would affect you professionally and some of the resources that you might be able to provide to your clients, such as 5 wishes, or helping them understand the importance of advance directives, or thinking about their own decisions in the end of life.